You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And this is your very special edition dealing with the new land law that the lawmaker says it is intended to revise, harmonize, and consolidate the laws on land to ensure sustainable land administration and management, effective and efficient land tenure, and to provide for related matters. And my guest in the studio, Mr. Gyan, is senior lecturer, University of Ghana School of Law, and Mr. Kofi Poku is former director, Public and Vested Land Management Division, Lands Commission. Right. So our guests, our audiences are so excited, super excited, and we thank you. Let me return, because there's a question or two for Mr. Gyan to take before I come to Mr. Poku to now give us his own take about all of this. So the first question that came up was from Jojo. Let's go to Jojo's question. He simply said that you did not explain the difference between common law freehold and customary freehold.
It's a very simple distinction.
Okay.
The common law freehold, the incidents, the entitlements that it brings you is determined by the common law as defined in Chapter 4 of the Constitution. So, if you go to Chapter 4, it sets out in Article 11,
right.
It sets out the laws of Ghana. And one of the sources of law of Ghana is the common law. And our common law, by our Constitution, the common law comprises of the rules generally known as the common law of England that we inherited, the rules generally known as equity, and our own customary law. So the common law freehold is governed by the law which is generally known as the common law.
Okay.
And that will be the English law which we derived.
All right.
The customary law freehold is governed by the customary law.
All right.
Of the place where the land is located.
Okay.
That's the main distinction.
All right. So, Jojo Afum, if you have an exam to write and you are not too clear, now you got it. Now you got it. There's this. Okay, Edu Murphy says, please make these land booklets available on the market. It is necessary. Okay. Please ask him who owns Koforidia lands. That is Jones Apenteng. Who owns Koforidia lands? And then maybe Beatrice Sophia Boahema says, my question is, can a newly installed chief summon property owners who have completed buildings to produce their allocation papers given by a previous chief under the law? Normally, upon production of the allocation papers, the new chiefs demand payment of drinks, money. For how long can this go on for successive chiefs?
Samson, if these chiefs had done what is right, any document they have executed in respect of any portion of their stool land, they should have copies of the documents in their own records.
Right.
One of the new things that are coming up is that this new law says every stool must establish a customary land secretariat where records will be kept like in the Lands Commission.
Right.
So the subsequent chief does not have to call the grantee of the previous chief to bring him or her the document before they know what has been given out.
It does appear Menchia has a better system.
Yes, they do.
Okay.
They have an excellent system.
All right.
The Chinese Secretariat also has one. But these two secretariats are historic secretariats.
All right.
I understand Bawe too.
Bawe one was set up under LAP.
Yes, it's doing very well. It has good records.
Under LAP.
Okay. Theo Aboga says, so what does the new law say about a situation where the people in my village hold the notion that women don't and can't own land? You heard the answer. In this instance, a woman who loses the husband and has no grown son automatically loses her husband's land. The answer has been given. That cannot happen any longer. The law abhors discriminatory practices on the basis of gender, including gender. All right, so I'll just read a couple of messages here, messages that may not require some response, and then I'll bring in Kofi Poku. This one's from Obi Rash. Says, thank you, Newsfile producers, for giving us the best. Then Big Boy AY says, this new land law is going to render a lot of chiefs useless because all they know how to do is to sell lands nyafu. Domelevos PA, is that your name? Domelevos PA at Owusu, you say that, but seriously, our chiefs should be put under check. The chiefs are selling the lands to foreigners and the monies are not used to develop the communities. A case study is Yeji, where almost all the arable lands have been sold to foreigners and farmers are being driven out. Edward Lanyon says, how consultative was the consultation prior to the Land Act? Some of the provisions are not easily practicable in our circumstances. Land administration system is not strong enough. I will be glad if you came back, Edward Lanyon, and told me which specific provision you find is not practicable and what your suggestion would be if you had been consulted. Azindor says that the law, history, and so much knowledge on Newsfile today. Thank you so much. And I'll read this last one. It says, Joy News TV Newsfile, is it right to buy land without title, but that has declaration from the Supreme Court? Do you understand his question?
I think he's talking about the judgment. Yes. You may not, if the Supreme Court has declared you as owner, and you know that the Supreme Court as the final appellate court, that declaration is probably better than a land title.
Right.
I advise that if he's a layman, he should consult a lawyer.
Great.
For proper legal interpretation.
Great. Okay. So there are a number of your questions. We are going to go to that leg of the discussion. Remember that we have segmented the discussion on a number of questions, including the one about women that some of you, particularly the ladies, are so concerned about. So you say, so the law requires that a spouse gives his or her written consent before a property can be sold, leased, mortgaged, etc. Now my question is, how fair is this to the spouse taking the mortgage when in some instances the other spouse might not even help in cash or kind? Now just get ready, we'll get to that aspect. And Mrs. Veronica Frimpong, former legal officer, Lands Commission and head of legal SIC Life Savings and Loans, will join us to begin that part of the discussion, when we will also open your phone lines, the phone lines for you to join with your direct questions. This program is brought to you by Bank of Africa, strong as a group, close as a partner. MTN, everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Duraplast, where Duraplast goes, water flows. Having mosquito spray and coil. Pleasant on humans, tough nightmare on insects. And Napa Food, it is tasty. DBS Industries, and Robert and Sons Limited Optical Services, your comprehensive eye care services provider. All right, so yes, let's hear which areas of this law, just come at you and you feel now we've got it right.
Okay, I must say, as a part of an overview of the law, is that the law is a consolidating law, but revises the existing law. So certain laws have now been collapsed under this new law. These are the State Lands Act, the Administration of Lands Act, the Land Title Registry Act, then Land Registry Act, as well as the Conveyancing Act and the Public Lands Protection Act. A lot of them, but these are the major ones that have been collapsed, and they have been put together under this law with a lot of significant changes made in. And one area that those in the land administration sector are very enthused about in this law is the issue of service. In fact, poor service have been the bane of land administration in the past. Within the records of Lands Commission are a lot of transactions that were based on wrong service. But this new law requires that every registration, recording of land, should be based on an approved plan. For the layman, for you to know what an approved plan is a plan that has the approval of the Director of Service or the regional surveyor. You can see his stamp on it. So a plan, you may engage a licensed surveyor to do a survey of your land for you, but if you intend eventually to register your land, you tell the regional surveyor, the licensed surveyor, to get the approval of the regional surveyor. Once you get that approval, it means that the position of your plan, of your land on the plan will be accurate, and it will be acceptable in the Lands Commission for registration. So this is one of the important changes this law has brought into being. And there are other very important changes that the law have brought, which some of them which I want to mention.
Yes.
Respect to the customary land secretaries. The law requires the Lands Commission working together with the Office of the Administrator of Stool Lands to assist the customary land secretaries to be set up, so that for the first time under the Conveyancing Act there was a provision for registration of oral customary grants, but it was never brought into force. So oral grants are not recorded. But under this new law, the customary land secretaries have been mandated to record oral customary grants. So if one is set up in your area, the customary land secretary is set up in your area, and you buy land, or you take a customary tenancy, any form of grant in your rural area, wherever you are, you can go and get it recorded. And it's also important that lawyers and people who are doing due diligence for the acquisition of land, not only should you make inquiries from the Lands Commission, you have to make inquiries from the customary land secretaries before you go ahead with transaction in respect of land, because it's now an important area for recording of land transactions.
Okay.
Let me see.
Yeah.
And then the other area that the law makes significant change is respect of re-entry and forfeiture. Under the old law, it appeared it involved only inconveniences, but the law now extends it straight away to customary grants. That even for customary grants, for the grantor or the landlord to forfeit the land, he has to abide with the provisions under the Act. It means he has to serve notices and require the grantee or the person who has taken the land to comply with whatever provisions of the grant he has breached, and before he can go ahead and repossess the land.
So explain that to us, re-entry. There are people who complain that I've been given a piece of land and then I'm told that I was supposed to have done something on the property in a year or two. Nothing has happened, so I have lost it. Is that what you're talking about?
Yes, that's what I'm talking about. Sections 57 and 58 of the law gives restrictions on re-entry. Re-entry is that the process whereby the grantor, the person, the landlord who gave the land to you, try to take the land back. Either he's complaining, you have not developed, you have not paid your rent, you have not done certain things in respect of the land, and therefore he wants to take it back. Or probably he wants to sell it to another person because he has gotten a higher price for the land. But the law is not prohibiting them. They cannot take it. The law says he should give you sufficient notice. It ought to be in writing, even though the grant maybe have been an oral. But because if you comply with the act, it means the notice has to come in written form. Write to you and tell you have breached A, B, C provisions of the grant. And he gives you sufficient time to remedy the breach. That I gave the land to you for cocoa farming. You have not started the cocoa farm. I want my land back. You give the person sufficient time, then to start planting the cocoa trees. If he starts, the re-entry fails completely.
But if he doesn't, then you can
go ahead with the re-entry.
Right.
So that's
very interesting. And that's also very, very important to people, because we live in a country where, as it were, you don't have service plots that are already available. You can go and get. So people go and acquire some lands and they don't have all the money.
Yes.
So perhaps all the money they have at that moment is what they have used to acquire the land. And now they have to now save again to begin to develop. And sometimes things don't go the way they expected. Somebody may have lost their job and they can't get on the land to do anything. So before they say jack, the land is being taken back. Now, this is a very good one. So if you can look at one or two more, and then I'll ask you a couple of questions that I have here, and
the law also under section 72 provide for civil and criminal liability for fraudulent concealment. So that if you enter into a transaction, and this one, you see, this one goes with the offenses. And the offenses are on 3 levels. The grantor, the person who intending to sell the land, or his agent, who conceals something from the purchaser, so that purchaser invests in the land, eventually to turn out that the land, what he bought, was not really what he bargained for. And probably has lost his investment. There is both civil and criminal liability. And it goes on to also give criminal sanctions to public officers who assist in that process in concealing information from potential purchasers of land, so that they put their money in a property investment which turns out to be a scam.
So what forms will that kind of concealment be? It's like you are deceiving the person to buy the property when you know that there's a problem with it. What would be some of the problems that you will not tell the person that, look, this land you are coming onto, these are the problems already on it. So
when I was in the Lands Commission, for the very first time, probably last year I was about to leave, we discovered that people have managed to forge what they call plottings in the government land area. Areas like Cantonment Airport, residential area, government land, they managed to forge things. They got some public officers, fraudulent people in there to plot transactions and produce documents. And there are some places somewhere in Accra where they can produce any official stamp, produce any signature. So they produce documents and these things. And out with that document, they are able to get you to buy land. And these are sophisticated tricksters who are working.
So that reminds me, and I know a lawyer who was leading a land transaction.
Yes.
And it's one of the prime lands in Accra. And the documents look so authentic.
Yes.
From the one who was giving it, as in the landlord.
Yes.
And this was an old, aged lady. You cannot suspect will want to do any wrong.
Yes.
But after the whole process was finished, and it was a company that was buying also, that was in the transaction. After a whole thing was finished, it was discovered, after thousands of dollars have been paid, it was discovered that the whole thing was a complete scam.
Yes.
Now the law says you can suffer punishment in that regard.
Not only the grantor,
okay,
but 5 is even talk about a professional,
okay,
So lawyers who are acting for clients without seeing them, interviewing them, doing due diligence themselves.
Okay.
You have been given a property because if people know a lawyer is involved, they have much confidence in the whole transaction. Professional surveyors who are also involved in these schemes, they should be careful. They are not led by these people. Or if I say a professional who knowingly assists a person disposing of property to conceal anything, will also run into problems.
Interesting.
So all these things are
it's where it says the issue of damages and penalty for fraudulent concealment. Let me just read it. That's section 72. A person disposing of property or an interest in property for valuable consideration, that's money often, to a purchaser or an agent of that person who with intent to defraud. So if you do these things, you conceal from the purchaser an instrument or encumbrance material to the property or interest. What does that mean? You conceal an instrument, encumbrance material to the property. What does that mean?
So it means there ought to be full disclosure. Like an insurance, you have to disclose anything. If you have mortgaged a property, of course you should tell him.
Good.
If you have give out a tenancy, long-term tenancy, you should tell him. If there is anything that will help the purchaser to decide either to invest or not to invest, anything that would have helped him to decide whether to invest or not to invest. If you fraudulently conceal that information from him, then the person has a right.
And it says if you falsify a plan of the land, then that is also one
that's
issue.
what I'm saying. The surveyors, all professionals involved should be careful in how they handle.
And if you are found out, then this is what you are going to suffer. You are going to pay as much as 5,000 penalty units. That's like 60,000 Ghana cedis. That's the least you pay. The least is 60,000 Ghana cedis, or 10,000 penalty units. That's like 120,000 Ghana cedis. Or in addition to that, you could go to jail for a minimum of 5 years or maximum 10 years. That's what you suffer if you conceal things. So we will come to look at the criminal sanctions that you have in this law, because they are very, very interesting. They say if you decided to extort money from some person, or you prevented a developer from developing the land, or that you did things like using force, violence, or intimidation to prevent or obstruct a lawful owner of land from developing the land, all of this, you could get into trouble. And if you're a trespasser on land, often what people do is that they hide, so you can't see them
identity,
and they think they are safe. The law says even if the trespasser is unknown, it could be dealt with. Let me now go on the phone lines. Are we on Zoom or phone? Okay, so we go to Zoom and welcome our third guest, Mrs. Veronica Frimpong, who is former legal officer, Lands Commission, and head of legal SIC Life Savings and Loans. Now, for those of you who are talking about the aspect where we ask the question whether this new law gives control to women, and we deliberately say so, women, over spousal property. Let's begin that discussion now. Thank you very much for joining us, Vero. Hello, is this Frimpong?
Thank you, Samson. Good morning to you, your panelists, and your listeners.
Right.
And viewers.
Right. So some of my guests have been eager, waiting for you to join. So good you say good morning to them as well. Now, what would you say briefly, because I know you have also had the opportunity of some sort of encounter with this new law. What would you say briefly before we go to the question of spouses or women?
It's a good law, brings a lot of introduction, innovations, and then at least tries to address some of the women's issues as far as property ownership is concerned.
Right. So you are excited to learn about the aspect that is against discriminating against women or anybody on the basis of gender not to own property. How much of, an impact will this make for particularly women in owning property?
Something, the important thing I noticed with this law is that there is somebody watching out for the woman, or in a marriage where property has been jointly acquired for valuable consideration, and that is the land registrar. Here, once it is not disclosed expressly on the face of the conveyance that the property was solely acquired by one of the spouses, then it will be presumed to be jointly acquired by both spouses, and then questions could be asked by the land registrar, who has such powers under section 102.
The line is breaking a bit. Do I still have you? Hello?
I'm on the line, something.
Great. So that aspect, we have had a number of men send questions to us, and they are not happy at all about it. Why do you think some man will not be happy about that provision of the law, requiring that when they are in a marriage situation, one party cannot sell the land, cannot mortgage it, cannot lease it, cannot give it as a gift unless the other one has given express consent?
Something that's a bit of a misunderstanding or misreading of the law. The law does not take away the right of either spouse to own property individually. No, that would be against the Constitution. Each spouse has the right to own property individually. However, where it is jointly acquired, then that is where the registration ought to be in the joint names of the parties, of the spouses, and one spouse cannot transfer without the express written consent of the other spouse.
Right. So the issue, as we know, is that once you are a couple, you are married, the law's presumption is that if there is property and it's not in anyone's name, then it belongs to the two of you. Is that what it is? And is that what is bringing the fear?
If it's in one spouse's name and it's not expressly stated to have been acquired by just that one spouse, then that spouse will be presumed to be holding it for himself and the other spouse as well. Because we know something that it happens most of the time. The couple acquires a property, but it's in the name of the man. The understanding is that it's for both of them. However, in terms of the registration, you find out that because one person's name, mostly the man's name, is on the conveyance, it is registered in the name of the man as if he's the sole owner.
How much of an impact will this provision make, particularly for spousal property ownership in favor of women? We know the facts that that's the problem.
Something I believe that this law is just the beginning. The issue of spousal property rights is big. It's bigger than simply saying that when property is jointly acquired during marriage, then it should be registered in the names of both spouses. More should go into a substantive law to address more issues, because even in terms of marriage, we know the types of marriages that are recognized under our laws. Some of our parents have been in supposed marriages for many years, but you can't classify their kind of marriage under any of the 3 recognized marriages in Ghana. And so it becomes difficult for them to even claim this kind of protection.
All right. Now, hold on briefly for me. And what do you say about this portion of the law, section 47, where it says, except as provided in subsection 3 and 4 of section 38, which is the exception that she brings in to say it's a misconception to say it's going to bring any problems, because you can actually own property as one of the spouse, husband or wife, separately. It says, in the absence of a written agreement to the contrary by the spouses in a marriage, a spouse shall not, in respect of land, right or interest in that land acquired or valuable for valuable consideration during the marriage, sell, exchange, transfer, mortgage, lease, and so on and so on. What's your view of it?
I think I agree with our lady friend who just spoke,
right.
learned colleague. There is no attempt by the law to prevent private property ownership of married couples. At some point in the deliberations around this particular clause, some of us were of the view, and I was in that school of thought, that this will not make a significant impact, because, like she rightly pointed out, if you go to Article 22 of the Constitution, it says that Parliament shall, as soon as practicable, pass legislation to regulate the property rights of spouses either during marriage or upon death of a spouse. And Parliament was given this mandate as soon as practicable after the coming into force of the Constitution of the Republic. This Constitution became effective on 7th January 1993. And Parliament has still not been able to enact comprehensive legislation to regulate the property rights of spouses. So what this provision sought to do is to complement the effort that the judges have already made in this area. There's been a lot of judicial activity to address the issue of property rights of spouses, starting from a decision of Justice Olenu in a case called Kote and Mate, where Justice Olenu said, if a woman assists the husband in whatever the man does in his station in life, the properties that are acquired through that joint effort were the singular individual acquired property of the man, and what the woman or the wife was entitled to was maintenance and support. So from that jurisprudence, the wife had no business getting property out of the marriage, but the judges on their own, without legislative prompting, moved the front all the way to where they are. And some of us felt, given where the judges had reached, we needed more comprehensive legislation, otherwise we will stifle the judiciary. But like she said, this is a good beginning, but it is not the end of the process. A much more comprehensive legal regime would have to be enacted pursuant to the direction in Article 22 of the Constitution. But at least we have started from somewhere. But we should also add another point. You are talking about property that is acquired for valuable consideration during the marriage. So it means if one party is gifted a house by their father in the course of the marriage, that property will not come under the purview of 38 and 47.
All right.
Because that will not be property acquired for valuable consideration.
Right.
So
if it's the wife's father who gifted to the wife, it remains the wife's own.
Exactly.
Until she decides otherwise.
Exactly.
Okay.
Or by inheritance or whatever.
Or by inheritance until she decides otherwise.
It also goes for properties that were acquired before marriage. So if you came in a marriage with properties, it's not affected by this provision.
All right. Now, the question that was sent in earlier, it says, so the law requires that a spouse gives his or her written consent before a property can be sold, leased, mortgage, etc. And remember what sort of property we are talking about here. Now, my question is, how fair is this to the spouse taking the mortgage when in some instances the other spouse might not even help in cash or kind in the repayment of the mortgage? Let me start with you, Mrs. Frimpong. What do you say about this question?
Samson, once the other spouse, in this case, we are talking more about the woman. Once the wife or the woman is a joint owner, it doesn't matter whether she would contribute to repayment or not. She should give her consent, because once there is a default, there's a risk that the property will be lost, and so she would have lost her interest in the property.
Right.
So the determining factor is not who is making the repayment, but the fact that the woman has an interest in the property.
Right.
And on this point again, a little bit of the difficulty with this is how we will protect vulnerable women. How do we ensure that the men do not force their wives to consent to such transfers and mortgages? Okay. And then I also noticed that from the Borrowers and Lenders Act 2020, Act 1054, which was also assented to in December 2020, we don't have similar provisions requiring consent for joint property. And so even though in the Lands Act, the consent is required, the easier route is to go through the lenders and borrowers, register at collateral registry, and realization of collateral there. It's even much easier than under the Mortgages Act. So that's another area that we have to pay close attention.
Okay, so we will take a quick break. When we return, I'll let my guests take us through the consequences, criminal more particularly, for some of the things that the law prohibits, starting right from Section 11 until we go to Section 277 thereabouts, and then we will take your questions and you will get your answers. This show is brought to you by Bank of Africa, strong as a group and close as a partner. MTN, everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Duraplast, where Duraplast goes, water flows. Heavy mosquito spray and coil. Pleasant on humans, tough nightmare on insects. And Napa Foods, it is tasty. DBS Industries, Robert & Sons Limited Optical Services, your comprehensive eye care services provider. This is Newsfile, special edition on a new policy law in Ghana seeking to help you in your acquiring a land and the state in how we manage land in this country, so that these fraudulent people who continue to, defraud people can be dealt with. My guests have been Kwame Gyan, Kofi Owusu, Poku, and Veronica Frimpong. We'll be right back.